The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Thank you for joining the New York Legal Assistance Group for Naturalization and Citizenship training. In order to receive CLE credit for this training, you will be asked to confirm your attendance throughout the webinar. We will be launching a pop-up poll question during the presentation, which will only stay on your screen for about 15 seconds. If you do not answer the poll, you will not be able to receive CLE credit. You will also be asked to submit a brief evaluation survey at the end of the presentation to confirm your participation through the entire program. For those of you who are watching a recorded version of this training, we cannot unfortunately offer you CLE credit, so please disregard these instructions. Thank you again, and I'll turn it over to NILAG staff attorney, Elvira Pinkosova.
Hello, my colleagues. Today's topic for our presentation is naturalization and citizenship. For today's presentation only, let's divide all those who are living in the United States into two groups, aliens and citizens. So let's do the following. All people who are living in the United States would be divided into two groups. Those who were born here or naturalized in the United States would be, for our purposes, called citizens of the United States, and anyone else would be called alien. The question arises, why so many people would like to become a citizen of the United States? First of all, it's the dream for most of those who immigrated here to live in America. And secondly, there are a lot of benefits for those who is United States citizen. Well, first and most important benefit is a right to vote. Only citizen of the United States is eligible to work for federal agency. Only citizen of the United States can be elected to serve as an elected official. Only citizen of the United States can bring in the qualifying relatives. For example, if somebody is a legal permanent resident of the United States of America, this person also can petition, in other words, file a relative petition for his or her spouse, children, unmarried children, and sons and daughters, but they should be unmarried. Legal permanent resident cannot petition for his or her parents or siblings, as well as married children. And only United States citizen can petition for the parents, siblings, and married children. United States citizen cannot be removed from the country at any time for any wrongful act or activity. United States citizen can travel with a passport for more than 36 countries in the world without obtaining a visa. United States citizen can live abroad indefinitely for many, many years. He is not obligated to enter the United States periodically. United States citizen is eligible to receive federal means-tested benefits. And finally, United States citizen can be selected as a jury. But we all know that if we have some rights, we have responsibilities. So what kind of responsibilities United States citizen has? First of all, if you would like to be a United States citizen, you have to give up all prior allegiance to any other nation. You have to swear allegiance to the United States. You have to support and defend the Constitution and the laws of the United States, and you have to serve the country if it's required. What kind of documentation you have to present in order to prove U.S. citizenship? First of all, it's birth certificate. All those who are born in the United States should be able to prove their citizenship by showing birth certificate. Passports, United States citizen passport as a second document. Certificate of citizenship and certificate of naturalization, as well as form so-called FS-240, Consular Report of Birth Abroad of Citizen of the United States. We are not going to talk about acquisition or derivation of citizenship during today's presentation. It's a topic for separate presentation, but I'd like only to say that children of the United States of America can derive or acquire citizenship through the parents, and the parent can file on behalf of the child the certificate of citizenship on Form N-600, or they can apply for the passport. And these two documents proving United States citizenship of the child. General requirements for naturalization. First of all, only those who are 18 years or older can apply for naturalization. Special rules applies for those who are served in military honorably during certain designated periods, but we are not going to talk about this during today's presentation. The next requirements for naturalization is a lawful permanent residence. Anyone who is applying for United States citizenship should be lawfully admitted for permanent residence in the United States. In other words, it means that any individual who was lawfully admitted for permanent residence and has a green card or Form I-551 alien registration receipt card is a legal permanent resident. To be eligible for naturalization, an applicant must show that he or she has resided continuously as a lawful permanent resident in the United States for at least 5 years prior to filling his or her application for naturalization, with no single absence from the United States for more than 1 year. Let's talk about it a little bit more. So, any legal permanent resident has to live in the United States continuously as a legal permanent resident for 5 years. Of course, anybody is free to travel, but the absence shouldn't be longer than 1 year. We will talk a little bit later about other exceptions. One of them is if the person is a spouse of the United States citizen living with the same spouse, U.S. citizen, for 3 years or more, and this entire time the spouse is a citizen, this person can apply for United States citizenship in 3 years, not 5 as a general rule, but 3 years. But the marriage, of course, should be bona fide. They have to remain married up to the time the person is naturalized. The person may also qualify after 3 years if he or she petitioned for permanent residence and became a permanent resident as a victim of domestic violence. Another requirement is that anyone who is applying for naturalization has to be present in the United States for more than 2.5 years, if we are talking about 5-year eligibility period, or for 1.5 years, if we are talking about 3 years eligibility period for spouses of U.S. citizens or victims of domestic violence. Those people have to show their physical presence for this time. And this person should show that he or she was not absent from the country for more than 6 months. If the person was absent from the country for more than 6 months but less than 12 months, we have to prove that the applicant didn't terminate his or her employment in the United States, that his immediate family remained in the United States while he was abroad. The applicant retained full access to his or her U.S. adopt, and or the applicant didn't obtain employment while living abroad. Sometimes the applicant has to take care of the sick relatives abroad, or student has to complete some specific programs abroad. Therefore, each travel of the period for more than 6 months should be properly documented. Absences from the United States for a continuous period of more than 1 year breaks continuity of residence. What does it mean? For example, the applicant is a legal permanent resident from the year of 2000. He was living in the United States for 2 years without leaving the country. And let's say in 2002, he traveled abroad to see his sick parents and had to stay there more than 1 year. He has all documentation showing why he was absent for more than a year. He came back in 2003. The question is, when his 5-year eligibility period allows him to apply for naturalization. We are not going to calculate 2 years from 2000 to 2002 while he was here. We will start calculating his 5-year period from the time he came back from his trip abroad. So from 2003. But we will calculate not 5 years, but only 4 years and 1 day. It's a special rule. 4 years and 1 day. So in 2007, he would be eligible to apply for naturalization if, of course, only if there are no any other problems. Absences from the United States for a continuous period of more than 1 year also have another limited exceptions. For example, those individuals who employed overseas for U.S. entities, religious organizations, and certain spouses of U.S. citizens employed abroad also would be eligible to apply for naturalization even if they were absent from the United States for more than a year. But in order to preserve residence for naturalization purposes, such people have to file Form N-470 in order to preserve their residence, and it would enable them to apply for naturalization. While calculating actual presence in the United States, we are counting days. Partial day in the United States can be counted as a full day if necessary. Calculation is frozen when the N-400 application is filed. Applicant, in order to be eligible for naturalization, has to reside within a state or USCIS district where he or she files the petition for at least 3 months. One lady applied for our assistance asking why her application for naturalization was denied. While talking to her, we realized that she was a legal permanent resident for 7 years. She was living in California. In the month when she moved to the state of New York, she filed her naturalization application. Because she was not a resident of the state of New York for more than 3 months, immediately preceding the application, her application for naturalization which she filed was unfortunately denied. Therefore, we have to be very careful in order to assist the clients who moved from state to state. We have to see that they are resident of the particular state or district for more than 3 months. There is no physical presence requirements during the period after the application for naturalization has been filed. Another requirement for every applicant who is applying for naturalization is good moral character. Every applicant must show that he or she has been a person of good moral character for the statutory period, 5 years or 3 years, or 1 year for those who discharged from our armed forces, prior to filing for naturalization. The service is not limited to the statutory period in determining whether an applicant has established good moral character. Bear in mind that every applicant is permanently, forever, barred from naturalization if he or she has been convicted of a murder. Also, applicants who was convicted for an aggravated felony after November 29, 1990, permanently barred for applying for naturalization. The term aggravated felony is in immigration context. It's nothing to do with aggravated crimes in the criminal context. Aggravated felonies are defined with a definition to a federal crime. Basically, it's those who convicted of one or more several serious crimes, especially crimes involving drugs and violence. Any person cannot be found to be a person of a good moral character if during the last 5 or 3 years he or she has committed and been convicted of one or more crimes involving moral turpitude. What does it mean, moral turpitude? Court of Immigration Appeals defining it as a crimes in which either intent to steal or defraud is an element. In New York State, such crimes as burglary, theft, forgery offenses, any bodily harm such as assault, sex offenses, murder, rape are considered crimes of moral turpitude. Those who has committed and been convicted of 2 or more offenses for which the total sentence imposed was 5 years or more, not eligible to apply for naturalization within statutory period. Those who committed and been convicted of any controlled substance law except for a single offense of simple possession of 30 grams or less of marijuana, also not eligible to apply for naturalization during statutory period. A person cannot be found to be a person of a good moral character if this person is not working and the only income he receives from illegal gambling. Those who smuggled illegal aliens into the United States, those who are prostitutes or habitual drunkards, who are practicing polygamy, who refuse to support defendants, who gave false testimony under the oath. All people are barred for naturalization for statutory period. Also, those who have been confined to a penal institution as a result of conviction for an aggregate period of 180 days or more, or has committed and been convicted of 2 or more gambling offenses, cannot apply for naturalization during the statutory period. Applicant has to disclose all information about all arrests, all convictions, all jail time, even if it happened before the statutory period, even if it happened in his or her native country. It's very important to give the truthful and correct information to the immigration officer. If somebody is still on probation or parole for a crime, it's better not to apply for naturalization because USCIS may deny naturalization application while parole or probation still pending. From 1980, all men between the ages of 18 and 26 are required to register with the Selective Service. Failure to register is a temporary bar for naturalization, but only if the applicant knowingly and willfully failed to register during this period of time. But if the failure was not knowing or willful, and the applicant can describe the situation why, what prevented him from registering for Selective Service, the applicant with the affidavit can file his or her, only his N-400 application. If the applicant knowingly and willfully failed to register, but his failure to register occurred outside the good moral character period, the failure to register is not an absolute bar for naturalization. If the applicant turned age 31, the failure to register, even if knowing and willful, is not considered as a bar for naturalization. Another requirement for applying to be naturalized citizen is attachment to the Constitution. Any applicant must show that he or she is attached to the principles of the United States Constitution. Everybody who is applying for naturalization must be able to read, write, understand words in ordinary English. Some applicants are exempt from this requirement. If on the date of filing, applicants who have been residing in the United States as a lawful permanent resident for a period totaling 15 years or more and are over 55 years of age, they take their citizenship exam, civics exam, in their native language, as well as those who are legal permanent residents for 20 years and reach the age of 50, also exempt to show the English language requirement. Applicants who have a medically determinable physical or mental impairment which prevents them from learning English also exempt from this requirement, but they have to submit the special form which is called N648 along with N400 application for naturalization. N648 form should be filled and signed by the doctor. It may be physician, psychologist, or psychiatrist. And the doctor has to state very clearly that this particular problem, inability to learn English, is totally depending on the mental or physical disability of this particular applicant. Any applicant who is applying for naturalization must demonstrate a knowledge and understanding of the fundamentals of the United States history and the principles and form of government of the United States. Only those are exempt from these requirements who, on the date of filing, have a medical, determinable physical or mental impairment, where the impairment affects the applicant's ability to learn U.S. history and government. Those who are residing in the United States for more than 20 years as a legal permanent residents and are 65 or older would be given opportunity to have simplified test. To become a citizen, everybody must take the oath of allegiance. By doing so, applicant swears to support the Constitution and obey the laws of the United States, renounce any foreign allegiance and or foreign title, be arms for the armed forces of the United States, or perform services for the government of the United States when required. In some situations where the applicant establishes that he or she is opposed to any type of service in armed forces based on religious belief, immigration would permit these applicants to take a modified oath. According to the law, which was amended on November 6, the year of 2000, Attorney General may waive the taking of the oath by a person if, in the opinion of the Attorney General, the person is unable to demonstrate or to communicate an understanding or meaning of the oath of allegiance because of disability or mental impairment. In this regard, the oath of allegiance would be done by the relative, spouse, or child, brother, sister, or legal guardian who is United States citizen by this particular applicant. So what is the process and procedure for those who decide to apply for United States citizenship? First of all, the applicant has to fill out a special form called N-400 application. It's 21 pages. We will give you detailed explanation how to fill out this application a little bit later in this presentation. But please know the following, that every space should be filled out, and according to the instruction, the form, no correction should be made in the form, nothing should be whited out, nothing should be crossed. It's a special requirement which were only recently provided by the government. Along with the application, the applicant should file 2 passport-size pictures, copy of the green card back and front, application fee in the amount of $595 plus $85 for fingerprints fee. Those who are 75 or older should not pay fingerprints fee, and other documentation. Depending on what basis the person is applying. For example, if the person who is applying for naturalization have been ever arrested in his or her life, they have to provide certified copy of disposition of arrest or court records. If the person is applying based on the marriage to U.S. citizen, they have to provide proof of spouse U.S. citizenship status and living in marital union, marriage certificate, proof of termination of all prior marriages, and so on. If it's a person between the age of 18 and 26, male applicant, they have to show selective service status information letter and other documents. After application is filed with United States Citizenship and Immigration Services, the applicant would receive Form I-797C, Notice of Action. In other words, it's called a receipt notice. It takes about 10 to 14 days to receive such receipt notice. But bear in mind that if you are requesting a fee waiver, certain applicants for naturalization who are unable to pay and receiving either public benefits or low-income families whose income is below 150% of the poverty level, or those who can show hardship in order to pay application fee, they might be exempt from the filing fee requirements, and the receipt notice would be taking a little bit longer than 2 or 3 weeks. After receipt notice, an applicant would receive another notice called Form I-797C, Notice of Action. They have to go to the Application Support Center to get fingerprints. FBI would do background check on each and every applicant. Only those whose checks are cleared would be scheduled in approximately 4 or 5 months for the interview. Background checks takes approximately from 20 to 30 days, sometimes more. If the applicant had several names used, it will take much longer. At the fingerprint appointment, the applicant has to provide a valid picture ID and the appointment letter. If the fingerprints not cleared, the applicant would be called for second appointment to be fingerprinted. If the fingerprints are not cleared again, the applicant is advised to go to a local police station and obtain good conduct certificate. In New York City, applicant can receive a good conduct certificate at one police plaza. After the interview is scheduled, the applicant must appear for his or her interview. He or she has to show his or her ability to speak, write, read, understand English, must have knowledge of history and civics, and to present all requested documentation. If the applicant fails the test, he will be called for re-examination. In the case of denial, the applicant can request a hearing under Section 336 of Immigration Nationality Act. If the matter is not resolved and the applicant still would like to prove his eligibility for citizenship, he can file mandamus in U.S. Federal District Court. At the interview, the applicant has to present alien registration card, all passports he had for the period of time he is living in the United States, Selective service registration. If applicant is willing and able to see the mock interview, he or she can find it at USCIS website, as well as 100 questions for civics exam. At the interview, the officer will place the applicant under the oath, will review N400 application, ability to speak and understand the English language. If the applicant didn't understand the question, it's better ask the officer to repeat the question. Applicant must correctly answer 6 out of 10 questions about U.S. history and government, must correctly write at least 1 out of 3 sentences and read 1 of out of 3 sentences. Applicant may be asked to provide any other documentation in order the officer is able to adjudicate the application. If applicant fails the test, he or she would be given another opportunity to come for the second interview. Under Section 336 of the Immigration Nationality Act, Immigration Service Officer is required to make his decision within 120 days of examination. If the decision is not made, the applicant can bring suit in district court. If the application is denial notice should be very detailed. It should set the facts, specific sections of law, conclusions of law, and the right to request hearing under Section 336 of Immigration Nationality Act. If the applicant passed the interview, he would receive a notice on Form N445, Notice of Mass Oath Ceremony. He has to answer all questions on the back, hand in green card, and he would be sworn in before U.S. District Court. Now let's talk about some problematic issues. First of all, when an application for naturalization is filed, the entire immigration record of the applicant is reopened. So Immigration Service may examine the basis of initial grant and continuing entitlement to legal permanent status. They would look if legal permanent status was fraudulently obtained. For example, you have an applicant, a young, beautiful Lady Marie. She came to the United States because her mother, who was legal permanent resident at that time, petitioned for her as a child of legal permanent resident. Marie was 16. The petition was pending for some time, and when finally the visa became available, she was 18. She just graduated her high school in the Dominican Republic. She went to U.S. Embassy, obtained a visa, her passport was stamped, and she had a party with her classmates, her relatives, friends, to finally say goodbye and to reunite with her mother in the United States. So Marie was saying final goodbye to her boyfriend, who was very upset, and he said, "Marie, you will forget me. You will forget me. There are a lot of good guys in the United States. Who would remember poor Pedro?" Marie said, "No, never. I won't forget you. I will bring you in to the United States as soon as I would be there." Pedro said, "Are you sure? Do you want to prove it? Let's go and marry me tomorrow." Marie said, "Yes." They married the next day, and the day after, Marie came to the United States. She entered the United States, received her green card in the mail. She was living here. As she promised, she petitioned for her husband, Pedro, who joined her in the United States. Everything is fine. Marie is a legal permanent resident for 5 years. She is 23. She came and she would like to apply for naturalization. Would we recommend Marie to apply for naturalization? We won't. Why? Because Marie entered as a child of legal permanent resident but the child of LPR cannot be married. Therefore, immigration officer can begin the process of getting back Marie's legal permanent resident card. Therefore, we won't recommend Marie to apply for naturalization. Another situation, Paul. Paul received his green card based on employment petition from his employer. Employer petition for Paul is good, specialist in computer engineering. Paul came here, received his legal permanent resident, and in 5 years thereafter, Paul came in order to apply for naturalization. You are asking Paul about his employment record, asking where he was working for the last 5 years, and Paul reveals you his employment, but it was nothing to do with the employer who filed his petition, his employment-based petition for legal permanent residence. So actually, Paul never worked for this employer. Therefore, we won't recommend Paul either to apply for naturalization because he might lose his green card. Or another situation. Pamela and Peter were married for some time. It was a very good family. Pamela came from Argentina and she received her green card as a wife of a United States citizen. But things didn't work out. And before removing her conditional residence status, Pamela and Peter broke up. They began to live separately. But they're still married. Pamela came to you stating that her 3rd year anniversary of green card holder is approaching. She would like to apply for naturalization. Would we recommend Pamela to apply for naturalization at this time? No, because she has to be a wife of U.S. citizen for the entire 3 years period. They have to live together, have the same household from the time she got her LPR status until the time she would be sworn in as a United States citizen. Therefore, in all these 3 situations, we would consult the applicant but won't recommend them to apply for naturalization. Some other additional issues everybody has to consider when applying for naturalization. First of all, if the applicant moved to another country since getting green card, lived there some time, got employment there, and came here back, but still didn't terminate his employment. Whether applicant has lied or committed fraud to receive, for example, public benefits, whether applicant claimed to be United States citizen or vote in any election, federal, state, or local, while being legal permanent resident. We have to know if the applicant has been charged with committing domestic violence, because domestic violence is a deportable offense. We have to review this case very, very carefully to do a lot of research before giving okay to file such application. We have to see all the trips the applicant made during the statutory period abroad in order to be sure that the trips are not more than 6 months or not more than 1 year. We have to be sure that applicant who is able-bodied adult failed federal taxes, or if not file federal taxes, why the applicant wasn't working, who supported the applicant. If the applicant supported his or her children who are not living with the applicant. If the applicant has any arrears in child support. We have to be sure that if it's a male between the ages of 18 and 26, that the applicant registered for selective services. If not, that it wasn't willful or knowing. We have to be sure about all the arrests if the probation and parole was completed. In all such situations, we cannot file application without prior examining all the facts, all documentation. Therefore, in any situation like that, the applicant has to see immigration attorney. Now we would go to review an 400 application, and in details will show you what you have to do while filling out the form.
Okay, hi everyone. My name is Deborah and I'll be taking it from here on out, just an introduction to the Form N-400, which is the application for naturalization. The first thing and most important thing about the application is that you need to fill in their A number. Everybody receives an A number upon receiving, upon applying for any type of immigration benefit. Where do you find this A number? It is on the green card, or it's also known as a lawful permanent resident card. Another name for A number is the USCIS number. These two numbers are the same. So this is where you would find it on the current green cards. The previous green card looks like this. It was not green. It was actually a yellowish color, and it did actually say A number. The current green card says USCIS number. These two numbers are the same and go at the very top of the application. We'll move on to part 1 about your eligibility. For the most part, people apply for application for naturalization after they've been a permanent resident of the United States for at least 5 years, or, as Elvira went through, have been a permanent resident of the United States for at least 3 years while married to a U.S. citizen. Part 2 is information about the applicant. It's pretty straightforward. The only part that might trip some people up is the date you became a permanent resident. Some clients will say, I've been here for 20, 25 years. Doesn't matter. The only date we care about is the date that the green card says you became a resident. Where is this date? It is at the bottom. It says resident since. From that date, we need to determine that it has been 4 years and 9 months, or 2 years and 9 months if applying based on marriage. The old card is in the same location. Other additional parts for the information about you for country of birth is straightforward. Country of citizenship or nationality, people often move around. Their country of birth may not be their country of citizenship. For this, we ask to see the passport, and that is generally the country of which they are currently a citizen. There are a few exemptions for taking the exam for English and civics. For the application, I believe Elvira also went through those. One big one is the N648 medical certification for disability. This will excuse you from taking the English portion and the civics requirement, but requires a separate form. If we run into any clients who need this form, we will give it to them. It is filled out by a medical doctor, usually preferably a psychiatrist, somebody who treats them for mental issues, not a general doctor. It's not for diabetes or cholesterol, anything like that. The impairment must be mental. The other exemptions, which Elvira also went through, are for the English language test. If you've been here for 15 years or more and you are 55 years of age or older, or you've been here for 20 years or more and are 50 years of age or older, this is where you would designate that exemption. Contact information, and then information about residence. They would like where you have been for the last 5 years. We start with the most recent and work backwards. You can show 4 addresses. Anything more than that, there will be an addendum. Information about your parents. They ask, were your parents married before your 18th birthday? This is to determine if somehow you automatically became a citizen through one of your parents. If they naturalized before you turned 18 and you were both green card holders, you automatically become a U.S. citizen with your parent. If mom and dad are still in the country from which they came, then you would just hit no, and that would be the end of this section. Information for criminal records check for gender. They want your height. Usually we copy this off their driver's license. This part's pretty straightforward, so we'll move on to information about employment and schools attended. This also, they're only interested in the past 5 years. Again, we start with the most recent and work backwards. They also want internships. They want when you were unemployed, or if you did anything that was unpaid, even volunteer work, I would say. If it was for longer than 1 month, we put it on the form. The trips outside the United States, this part is very important. Elvira also went over why, as it can affect your green card status. They're only interested in the last 5 years. On the old form, they were actually interested in all trips you've taken since you became a permanent resident. So this form is a little bit better in that way. They're only concerned with the last 5 years. Have you been in the country for most of the time over the past 5 years, and have you ever taken a trip outside the country that lasted more than 6 months? Again, here we start with the most recent trip and work backwards. If we need additional space, there will be an addendum for that. In addition to asking the client about their trips, generally how we determine this information is to go through their passports. Many countries will have exit stamps and entry stamps. The United States does not stamp your passport when you leave. It only stamps your passport when you enter. Like I said, other countries will have an entry and exit stamp. So we'll go through the passport and we ask them to bring all passports that were valid since 2009, and we go through each page and look at the stamps, and that's how we determine these dates. Information about marital history is pretty straightforward. If they are currently married, they provide that information. We will also ask for the marriage certificate, and a lot of the information can come from there. If the spouse is currently a U.S. citizen, we say yes. We ask to see the spouse's certificate of naturalization or passport or birth certificate if they were a citizen upon birth. If they are not a U.S. citizen and are a green card holder, you can check that they are a green card holder. If they are not currently a permanent resident, or they're here without, oh, sorry about that. if they're in the U.S. or are here without status, you would write that they are a foreign national. If they're in the U.S. on a work visa, then he or she is a lawful non-immigrant. I say work visa because that's the most common one, but if they're on here on any other sort of valid visa, they would be a lawful non-immigrant. The second part has also been expanded from the previous form. How many times has your current spouse been married? Not only do they want to know about your current spouse's previous marriage, they also want to know about your current spouse's previous spouse, meaning their date of birth, their country of birth, their country of citizenship, all of that. And again, if they were a U.S. citizen or a permanent resident, or you would write foreign national if they're here unlawfully, or if they're abroad, or if they are here on a valid visa, they would be a lawful non-immigrant. After they ask about your current spouse's previous spouse, they ask about your previous spouses, and this would be the same information. And for this, we require certificates or judgments of divorce for yourself and your current spouse. Okay. If either of you have been married more than twice, meaning more than your current marriage plus one divorce, we would have an addendum. We would need a second judgment of divorce or a third judgment of divorce, or if your marriage ended due to a death, we would ask for a certificate of death, and the information would be provided on an addendum, like the one you see here. Information about children. This part is important, and it's also important to note that all children should be indicated, whether they are in the United States or living abroad, whether they've ever even been to the United States, they need to be listed, whether they're married, even if they're already grown and grandparents themselves, all of the children should be listed. Here they give you space to list information about 4 children. If the client has more than 4 children, we would add an addendum, which looks like this. Now we come to the all-important security questions. Each one of these questions, and it spans 3 pages, need to be asked in a way that the client will understand. So you can reword it if you can get the point across to them in a better way. However, each question needs to be asked. The big question here is about taxes. Do you owe any overdue federal, state, or local taxes? If yes, they need to have that taken care of, even if they get put on a payment plan. As long as they can submit proof of that, it is still okay. We can file for them. If they have not filed taxes for any year since they became a permanent resident, we need to have an explanation. The explanation can be as simple as I was a student and was unemployed, or simply I was unemployed in the years 2004, 2005, 2006, and therefore I didn't need to file taxes. If there was any other information, like they did work, but I only made $5,000, and under United States tax law I'm not required to file taxes, then we would write that explanation. These are a few more security questions. You guys can go over these in detail if you want, but for the most part, we ask them very quickly, and unless they say yes to one of them, yeah, we can move through them very quickly. If they do say yes to any one of them, it will require an addendum and an explanation. So we ask questions like, have you ever been associated with the Nazi government, ever involved in any way with genocide or torture, killing, badly hurting forcing to have any kind of sexual contact or relations, or not letting someone practice his or her religion. And this goes for in their home country or in the United States. This question asks about military involvement. Question 16 asks if they were ever a worker in a prison or jail or prison camp or detention facility. If someone did work for a prison or a jail at some point as a civilian, say they were a chef or they did administrative work, we would still need to say yes and provide an explanation. The rest of this is pretty straightforward, and now we come to the criminal history questions. Have you ever been arrested? Have you ever been charged? Have you ever been convicted? Have you ever been placed on probation? Have you ever been in jail? If the answer is yes to any of these things, we require an addendum. We also require a certificate of disposition. And that looks like this. This is a sample of one from Queens County. New York County looks the same. It depends on where they were arrested is where they would go. The criminal court usually charges $10 for it. If you have your ID, they can access it right away and print it out for you. You can walk out the door with this disposition. They want to know where it happened. They want to know what happened. They want to know how it ended. And they want to know when it happened. So where was Queens, date of arrest. The arraignment charges, usually we will look up online to see exactly which one they fit under, is what we would write in the why were you arrested, cited, detained, or charged box. And then for the outcome, for example, this one would be pled guilty, fined. That would be it. There are more security questions that go towards your moral character. Again, if the answer is yes to any of these, we need an explanation and an addendum. Questions 33, 34, 35, and 36 are important. We ask if they've ever been removed, excluded, or deported from the United States. And some ways that we ask this are just to find out their entire immigration history. Have you applied for any other relief from USCIS? Have you ever been to immigration court? Why were you there? When were you there? If the answer is yes, they will require additional documentation and explanation. We should find out the current status of their immigration proceedings. If you are a male in between the ages of 18 and 26 and are in the United States as a lawful non-immigrant, you need to register for selective service. If they were here during college, I believe colleges and universities will take care of this for you, but you need to make sure that they have documentation of this, and what that will look like is the following. If they do not have this, if they did not register, and they were here between the ages of 18 and 26, they will have to provide an explanation. Like Elvira said, it has to be unknowingly and unwillingly not registered. If they are still between the ages of 18 and 26, they will need to go register and provide proof thereof. The last few questions are towards allegiance to the United States. 48 says, do you understand the full oath of allegiance to the United States? This is not the Pledge of Allegiance. It is an oath that the officer will conduct at the interview, and it is at the end of this application in Part 17. Looks like this. You can read it to them, and they can say yes. Okay, and now come to the signatures. the client will sign, and as a preparer we would also sign below that. If an interpreter was used on this form, the client signs in two places, in Part 12 and in Part 14, to designate that they used an interpreter, and then below them the interpreter also needs to sign the form. The last page and a half of the form is to be completed at the interview in front of the USCIS officer, so we do not touch this section, but again, if they want to know what the oath of allegiance is, it is in Part 17, and this is the last part. So this concludes our webinar. If there are any questions, you can type it in. I think I'll give it a few seconds. Okay, I'll just conclude. We hope you enjoyed this webinar training. If you have any follow-up questions, you can email us at webinars, that's plural, at nilag.org. Please remember to complete and submit the survey evaluation that will follow the end of this webinar in order to receive the CLE credit. Thank you, everyone.